You have none. So we can listen to speak, and then it's
I'm Chris Burrell, President of the Magic City Bar Association. Thank you so much for joining our Social Distancing CLE series. We've got great information brought to you by great judges and attorneys, and we know that you'll get a lot out of it. The month of August has so many things that we need to acknowledge. From the 100th anniversary of women's suffrage and how that intersects with the right of every American to vote, to the historic nomination of Kamala Harris as Vice President of the United States. There are so many things for us to acknowledge. But we must also acknowledge that August is Black Women's Equal Pay Month. That's the point in the year that a Black woman has to work in order to make the same amount of money as her white male counterparts. What better way to show the absurdity in that disparity than to have the awesome presenters that we have here today. After today's CLE, we need 3 things from you. 1, use the link in the registration email to submit feedback and attest that you attended the CLE virtually. That way, you'll get credit with the State Bar. 2, if you're not already a member, go to www.magiccityBarAssociation.org and join today. 3, go to Facebook, like our Facebook page, and share it with your friends. Thanks for being here. Have a great day, and we'll now turn it over to our CLE presenters.
Wow, thank you so much. First, let me just say thank you to Mr. Burrell and to the Magic City Bar Association for giving us this opportunity to present to you guys. And I thank you for caring enough to put forth the energy and the time and effort. I know this has not been an easy undertaking. And I just really appreciate the time, the effort, and the work that everyone has put into making these CLEs possible for all of these wonderful attorneys. So in this hour, Attorney Washington, Attorney Gary, and I are going to be presenting on the modern family. You know, today's best practices in family and domestic relations court. And I'm going to ask one thing of you. So Chris asked you for 3 things. I'm going to ask you for 1, okay? And what I would like is I would like some participation from you guys, okay? So either you can submit your questions through the chat function, you could submit it to the group, you could submit it to us individually, however the case may be, but engage with us a little bit, talk with us, and let us know so that we can make this the best possible CLE, okay? With that being said, let's dive right in. So in talking about modern family and practicing in DR and family court, a lot of new attorneys, especially more so than others, always want to know, well, what's the secret? How do we get this done? You know, and then there are books that come out every couple of years, you know, The Secret Revealed, The Secret Made Simple, How to Use the Secret. And if you're like me, you're a book junkie, you like to read a lot, and you read all of these different books. And what you find out is that typically when you read these books about what's the secret to life or success or the practice of law, you discover there are things that you already knew in the first place. The only difference is it may be not our focus. And so what I want to engage with you about this morning is, what is your actual focus in the practice of law? In family court, as many of you, if not all of you know, we deal with dependency cases, delinquency cases, VASCALs, PFAs, child support matters. Likewise, in DR court, there are child support and divorce matters that we are addressing. But what do you focus on? Is it your clients that you focus on? Is it the billing that you're focusing on? Is it the judge that you're focusing on? There are some things that we just cannot change, okay? And you know, if your client is an alcoholic, if he's an abuser, if your client is has a criminal history, there are some things we cannot change. The case your courtroom is assigned to, unless it is set before a referee, there are things you cannot change. What does the law say when a person has been convicted of sex abuse of a child. There's certain things you cannot change. But what you can change, though, is your preparation. What type of investigation have you done into the facts of the matter? What type of legal research have you done? Have you prepared your client? Oftentimes in my practice, I would always sit down with my client when possible. If not, I would send them a letter or a phone call just to go over with them how to conduct themselves in court. Back up, how to dress when they're coming to court. I would talk to them about how to present themselves when they come to court, how to engage, how to answer questions, talk to them about their temper, talk to them about their demeanor. You know, legal research, every week we have cases coming out of Montgomery telling us about different changes or nuances in the law. Do you consistently keep up with those things? Are you consistently reading so that you're abreast of all of these changes? What about your witnesses and documentary evidence? Do you have all of that laid out ahead of time? How much time are you actually spending? For me, it's nothing worse when I was practicing to have witnesses get on the stand and have no clue what they were going to say. And so what I would encourage all of you to do is to change your focus and make your focus on things that you can actually change. Now, with that being said, there are 3 topics that I want to go over with you today that may or may not be part of your everyday practice. I've tried to divide it up a little bit so that hopefully I will catch most of you in those categories. The first is in filing private dependent petitions. DHR, also known as the Department of Human Resources, is not the only agency that can file a petition for dependency. Any individual who has concerns regarding the welfare of a child can go to intake and file a petition for dependency. Now, some of the complaints you may hear from time to time, well, it takes so long to get a hearing though. But that is not always the case. Once again, it's all about your focus and your preparation. I need you to take the time to know exactly what means are available to you. What do I mean by that? The law allows for private individuals to even file emergency ex parte orders prior to service on the parents. Now, absolutely, it is not to be taken lightly. That is something that we withhold for the most serious of circumstances. But if a child's life is in danger, if there are concerns and you want to file a petition, you know, oftentimes you're told, well, before the courts can make any changes, there have to be service of the parties, but that's not always the case. The caveat to that is this though. If the court grants you a request for an emergency ex parte hearing, that would be where it's only one side telling the story and maybe the other side hasn't even been notified of those proceedings, then the court has to have a 72-hour hearing to allow the parents an opportunity to respond. So how does that work in the reverse? If you are representing a parent, if a parent has come to your office and said, hey, these people have taken my children, they say they have a court order, I never even received notice of it. Your right as a parent, your right as an attorney on behalf of that parent would be to request that 72-hour hearing if it has not already occurred, and hopefully it has. Likewise, similarly related thereto, let's say it is a DHR dependency case where DHR has filed petitions to remove the children from their home, and there was a shelter care hearing and mother or father wasn't able to attend the shelter care hearing. They didn't receive notice of the shelter care hearing. They didn't know about it. Well, the law says 1215-308 Part E. It says that they have a right to a hearing within 24 hours. I'm gonna say that again. If there is a shelter care hearing whereby DHR has petitioned the court to remove the children from the home, and mom or dad was not notified of the hearing, mom or dad was not present for the hearing, immediately they have a right to a hearing within 24 hours. 12-15-308. Now, let's talk about what gives them cause to remove children from the home. What gives them cause? The fact of the matter is, it's about safety and welfare of the children. If a child is in substantial and imminent risk of harm, then the state can petition the court for removal of the child. But you also need to understand this. If you're representing a mother or father, you have a responsibility to ensure that the department has complied with the rules and regulations thereof. And I think that some attorneys may not know where to go to find out what all is required of DHR. And I'm going to tell you where you can find all of that. That is in the administrative code. So we're going to flip ahead 2 screens instead of just one, because we're going to go ahead and get to the Alabama Administrative Code. The Alabama Administrative Code, which you can access several different places. For example, if you're a member of Alabar, you can go on to the free legal research tools that they have for all members of the Bar Association. It's also on the state's website, that alacourt.gov. You can go there and click on resources. And so everyone has access to the Alabama Administrative Code. The Alabama Administrative Code sets forth what is required of the department. So if you're representing a mother or a father, I encourage you, even at that very first shelter care hearing, to examine the facts of the case. Examine if the department has done all they are required to do prior to the removal of that child. Now, granted, there are exceptions to every rule. That's one of the first things we learn when we're in law school, right? There are exceptions to every rule. So if it is of such that a child has been harmed or there needs to be immediate action, the department is right. If there needs to be immediate action, they don't have to go through what we call reasonable efforts, okay? If there needs to be immediate action. But let's determine if there needs to be immediate action. How do you determine it? And that's what the first administrative code I have up for you today. That's chapter 665-34.06. It goes through a list of 5 factors that needs to be assessed and considered in determining whether or not a child is safe. So at shelter care, one of the things you can do if you're representing a mother or a father, or even as a GAL, put that social worker on the stand and see if they have truly assessed whether or not that child is in a safe environment. 6, there are decisions about providing services on the next slide that we're going to look at. It says that the county department must make reasonable efforts and offer all appropriate services to prevent removal unless that child is in immediate danger. So the question is, if there are concerns about the safety and well-being of the child, but the child is not in immediate danger, there should be some intervening steps before they actually come to court. I'll say that again. If the department is concerned about the safety and well-being of the child, but the child is not in immediate danger, then there need to be steps that take place before court intervention is requested. Court intervention should be requested when there is an immediate danger to the child. Court intervention should be requested when other ameliorative services have been offered, but the parties choose not to accept them, not to engage, okay? That's when court intervention should be used. And that's also set forth in the Alabama Administrative Code, and I'm going to show you now where you can find that. That is in chapter 660, you can go to the next slide, 660-5-34.11. This section of the administrative code sets forth when court intervention should be used. Now, the second topic I want to talk to you about is that of ICPC. That appears to stump some of the attorneys that come in my courtroom. ICPC is an abbreviation. It stands for Interstate Compact on the Placement of Children. But you need to understand there are rules governing when it is required and when it is not required. And so I challenge all of you to familiarize yourself with the rules governing when it is required and when it is not required. And now that I'm mentioning that, I need to say also, I don't think I actually put it on this slide or not. That's okay. But this is also codified in Title 42 of the Code of Alabama, okay? So now I'm gonna show you my church background. You know the difference between the Bible and the commentary? I think of the code more like the Bible and the administrative code more as the commentary. And I say that only because the code gives us some blanket rules regarding each of the things I'm covering with you today, but the administrative code goes into much more detail. And so it is not enough, in my opinion, for you just to be familiar with the codified version of this in the Alabama Code. I encourage all attorneys to be familiar with the more detailed descriptions provided by the Alabama Administrative Code. And that's why I wanted to spend some time on this today. The next thing I want to tell you about ICPC is there's another rarely used tool regarding ICPC, and that is a regulation number 7, priority placement. Now, the only time I typically see this in cases when we're dealing with a child under the age of 2, but that is not the only time you can use a priority 7 ICPC. Priority 7 ICPC can also be used when there's been a very long delay. How many of you as attorneys have requested an ICPC on behalf of your client and it's taken 6 months to hear anything back, 7 months to hear anything back, 8 months to hear anything back? And it seems like some people just throw up their hands. But there are tools available for you to continue to advocate for your client. And in fact, you may want to request a priority 7 based upon that delay. Now, there are some requirements regarding that, but you can find all of that in the administrative code. For example, part of that requirement is that we need to know that the receiving state has sent to the sending agency all of the required documents necessary for the ICPC. That is one example of things that are used. But I say that because I want you to know that there are other tools and mechanisms you have available to you that I don't believe many attorneys are actually using. Another tool that can help you is, according to the administrative code, it also allows for special circumstances where a child has previously lived with that person. So let's say you have an aunt in Missouri, an aunt in California you want to send a child to. If that child has a pre-existing relationship with that aunt and they've lived there before, by way of example, then use that to your advantage and cite the Alabama Administrative Code. Ms. Jenkins, how you think we're doing so far?
You're doing good, Judge.
Okay, great deal, great deal. All right, now, and I actually did include that in the next slide, I do believe, the codified version as well. Okay, so we'll go to the next slide. Look at me looking out for you guys. Okay, so Title 44-2-20 covers ICPC. And of course, please know that I did not put the entire administrative code sections, nor did I put the title, the entire Code of Alabama related to each of the things we're discussing in the slide. I just pulled out certain relevant, pertinent parts for us to discuss today, but you have the code sections available so that you can go back and read them in its entirety and familiarize yourself with them. And if it has not already been done, I'm sure Mr. Burrell is going to make these available to anyone who wants them, okay? That's what they're here for. Now, the last thing I want to talk about before I turn it over to Ms. Washington is there's some case law that I think could help several of you that come into my court, and I want to make you aware of them. So let's talk about them now. That's just me taking a break. I've been running my mouth for a minute. Okay, so the first case I want to talk to you about is JY versus Geneva County Department of Human Resources. I don't know exactly how many people is watching this CLE right now, but I'm going to tell all of you a secret, and I hope that you all will keep it a secret. This is a secret for real. This is not about the focus. This is actually a secret for real. So in my practice, in family court, almost all of the cases when you're researching has initials only, right? And though I have an excellent memory and ability to recall, when it comes to initials, it's hard for me to remember initials of cases so that I can cite them. So I give each of the cases a name. And so instead of JY, I'm not going to tell you what I use for it. That'll be a little too much. And it's not people's names. It's just phrases, catchphrases that help me remember the case. But anyway, in talking about JY versus Geneva County Department of Human Resources, I say that because it will help you when you come to court if you can actually cite and reference the case law. And I know it's hard to remember when it's so many different initials, but there you have it. This is a case about abandonment, okay? In JY versus Geneva County Department of Human Resources, there was a father who appealed the termination of parental rights, and he won based on no proof of abandonment. And what's really interesting is that at the time, he was incarcerated and had been for more than a year in the state of Florida. So I want to talk to you a little bit about what the appellate court said when the father argued that DHR was wrong and that he had not abandoned the child. This is what the courts asked themselves. One, was he ever offered visitation? Had he been communicating in contact with the child, looking at both before his incarceration and, if applicable, after his incarceration? Did he fail to provide financial support for the child when he was able to do so? That's important because you may hear some say, well, this mother, this father, they have not provided any financial support to the child. Well, the law says you only consider that if they were able to provide financial support and fail to do so. Obviously, if he's incarcerated and he doesn't have any assets, he's not able, so you can't hold it against him that he did not provide financial support to the child. Likewise, his incarceration is not something he volunteered to do, right? So you don't hold that against him. You look at what type of involvement did he have prior to his incarceration, and if you have a parent that's released, what type of involvement do they have after their incarceration? What type of reasonable efforts did the department offer to this parent who had been incarcerated? And if you can say that, if you can answer all of that questions in your client's favor, at least in JY versus Geneva County, he was successfully able to defend the claims of abandonment. How about that? Okay, so another case I wanted to tell you about was LMF versus CDF and CF, okay? So, all right, let's just talk about it. In family court, more so than in domestic court, but you do see it in domestic court as well sometimes. Oftentimes people would just talk to the judge, you know. They don't really put anybody on the stand. They don't really swear anybody in as witnesses, okay? And they just talk to the judge, and sometimes they'll get an order making some type of changes. LMF versus CDF says this: there was a case that was set for trial. The party showed up, but no trial was held. Everybody was pro se in that case. And in that case, what they did, they went back and talked to the judge, and they discussed the case. They told the judge what they wanted the judge to know, and the judge made a decision based upon their discussion. There was no sworn testimony. There was no cross-examination of witnesses. But this judge entered an order changing custody based on that discussion. LMFs, that case was reversed. They said you cannot modify custody without evidence. What am I saying to you? Discussions, arguments are not evidence. Discussions, arguments, they're not evidence. You can't expect to sway the court with things that are not evidence. And if it ever goes up on appeal, that's what they're going to tell you. It's not evidence. So file in your evidence, whether it's affidavits, whether it's documentary evidence. Put some people on the stand. You got your testimony. That's evidence. Now, let me say this too, though. If the parties proceed with allowing the parties to testify, it's not necessarily reversible if there is no objection. And I want to distinguish between testifying and discussion, okay? And what I mean by that is this. One by one, a person can testify, but let's say they weren't sworn in first. If a mother or a father is testifying to the court, but they were not sworn in, the court can still consider that as long as no one objects, okay? So if there is no objection, the parties can testify to the court, and so they noted that in LMF that it's not reversible to present unsworn testimony if there was no timely objection. Okay, so there is a distinguishable fact there. But the important thing I want you to take away from LMF, and I encourage all of you to read that case, is that arguments is not evidence. All right, last case I'm going to talk about, and then I'm going to pass it over, is Jacquese versus Madison County DHR. Jacquese versus Madison County DHR is a case about drug abuse. In this case, there was a long-standing substance abuse issues by the mother, but the court said that that does not equate to abuse or neglect of a child in and of itself. What do I mean? Well, in Jacquese versus Madison County Department of Human Resources, the mother had stable housing, the mother had employment, the child was doing well in school, the child was attending school regularly, and everyone agreed that the child was well adjusted. And so termination of parental rights was reversed in Jacquese versus Madison County, even though mother had a long-standing history of drug abuse issues. All right, so I hope that you are typing furiously, getting all of your questions and comments in. And as you're doing that, I am going to pass the torch at this time to Ms. Jenkins. And if we have some time, at the very end, I'll come back with some personal tips from various judges in both DR court and family court. Thank you all so much for your attention, and I hope it helped in your practice. Ms. Washington?
Thank you, Judge. Thank you, Judge Ruffin. Hello, everyone. My name is Benita Jenkins Washington. I first want to say thank you to the Magic City Bar Association, and thank you for Chris Burrell for getting the CLE together. I really appreciate the opportunity. So I normally practice in family court and domestic relations court. And during the pandemic, during coronavirus, there's one area that hasn't slowed down in my practice, and that's issues involving domestic violence or domestic abuse. I've seen an influx in those kinds of cases. So today I wanna delve a little deeper into that area and talk about one of the main avenues in the family law process that is used to protect victims in situations involving domestic violence. All of the things that I discussed today can be found in the Protection from Abuse Act, starting at Alabama Code Section 30-5-1. Okay, so first we're going to look at, just a second. What is the Protection from Abuse Act? This act allows for the victim in domestic violence situations to file a petition with the court requesting protection from the abuser. If the court grants the petition, it will enter a protection from abuse order, often referred to as a PFA. PFAs are unique in that a PFA is usually granted ex parte. This basically means that the alleged abuser will not be notified right off until after the court grants the petition, and while it's still effective. This is important and crucial for the PFA process, given the possibility that an abuser could be infuriated that the victim has filed their petition with the court and puts the well-being of the victim in jeopardy. So to delve a little deeper into the hearings on PFAs and temporary orders thereof, let's look at 30-5-6. The court shall hold a hearing after the filing of a petition under this chapter upon a request of the defendant or within 10 days of perfection of service. A final hearing shall be set in which the standard of proof is the preponderance of the evidence. If the defendant has not been served, you typically see that the court does allow a continuance until service has been perfected. The court can grant a continuance until perfection of service, or until the court can reasonably fit that hearing date on the calendar. So when an ex parte is first initiated, or when a victim comes to the court to ask the court for relief, if it's not granted right off, the court does have 3 days to grant the filing of that petition. Who can file a petition for a PFA? You have to qualify to file a protection from abuse petition. The victim has to qualify or have a qualifying relationship with the abuser or defendant. These relationships include: victim is the defendant's current spouse or former spouse. The victim and defendant have a child in common. The victim and defendant had a dating relationship. The victim is the parent, child, step-parent, or stepchild of the defendant and lives with the defendant. Or you sometimes see that the victim lives with the defendant and had an affectionate or a sexual relationship with the defendant, or was related to another person living in the home who had such a relationship. What is domestic abuse? We can look at Alabama Code Section 30-5-2, subsection 1 for a list of crimes that constitute domestic violence for purposes of filing a PFA. And some of those are arson, assault, attempt, child abuse, criminal coercion, criminal trespass, harassment, kidnapping, menacing, reckless endangerment, sexual abuse, stalking, theft, and unlawful imprisonment. There are a plethora of reliefs that you can ask for when filing for a PFA. It's really going to depend on the facts and scenarios found and contained in the PFA. But some of the relief that you typically see when a victim files is that the court can order the defendant to refrain from committing any additional acts of abuse, order the defendant to cease from contacting the victim altogether, order the defendant to stay 300 or more feet away from the victim's home, place of employment, or school. If the parties do share a child in common, the court can award temporary custody of that child to the victim, or they can even order child support and refrain the defendant from contacting the child until a hearing can be held. And a lot of times in those cases, almost always, a GAL is going to be appointed. sometimes can even be an award of the victim the sole temporary possession of a shared residence, an automobile, or personal effects. Some of the other things that can be asked for when filing a PFA at the final trial is that the defendant can be prohibited from transferring, concealing, encumbering, or otherwise disposing of property that is mutually owned by the victim and the defendant. The court can also order the defendant to surrender all firearms. Once the defendant has been served with the PFA and during that final trial, after all evidence is substantiated, the court does have the right to put into place a permanent PFA order. That order can be in place for months at a time, or it can be in place until 2100. It says 2099, but I'm seeing now that the court is using 2100. How does one file for a petition for a PFA? The required petition forms can be downloaded on the Alabama Administrative Office of Courts website on the eForms page, or the victim can go straight down to the family court clerk's office and pick up the documents right there. This concludes my portion of the topic of the PFA. I'm going to turn it over now to my colleague and friend, attorney Jacquese Gary, who is going to talk to us about the COVID-19 pandemic, some of the things that we have seen with evidence introduction and courtroom etiquette. Attorney